welcome back to the channel. We have our lovely guest here again, Mr. Alan Robert Shaw. How are you doing, Al?
I'm doing very well, thank you.
We thought we'd do a pre-record for obvious reasons for you today on a subject of discussion, literally discussion, freedom of speech, expression, and our Article 10 from the Human Rights Act and ECHR. Lots of people, particularly with the Alex Belfield case and a few other cases that have hit the media, have quite rightly asked questions about freedom of speech, freedom of expression, whether there is a right to the freedom of expression, whether it's an absolute right or a qualified right, or whether that right or freedom is being trampled on, is, I suppose, one way of putting the discussion. So we will start by looking at where this all comes from. And Al and I will discuss fairly generally all of these issues without, as you understand, we cannot speak on any one case in particular. But starting with Article 10, because Article 10 provides, and everyone would be forgiven for thinking that this is an absolute right to say anything you wish, it begins by saying everyone has the right to freedom of expression. Now, if you read nothing else, you might think you can say absolutely anything you're right, but that's not right, is it, Al?
Not at all. This is something generally with rights. There are absolute rights, like, the right to life, but then there are what we call qualified rights, which is, here's a right, however, it's not an unfettered right, and there are certain restrictions. And you get that a lot with, especially with the ECHR, because they have this idea that it must be something that you can make laws that fit in with the smooth operation of a modern democratic society. So it's not a complete free-for-all. And this is similar. We will compare with the sort of the US position as well, because there's also this week been a very important case from a US perspective about freedom of expression. So American viewers, please stay tuned. We're not excluding you. We
Absolutely do not. No, we will certainly come. This does affect, well, there is, as Al said, there is a case which affects the US viewers, and indeed, law is almost always somewhat international and universal. Of course, each jurisdiction will make its own decisions and make its own rulings, and sometimes overrule those of other jurisdictions, but some of them are sort of naturally international.
Well, especially with social media, because this is, we're a global linked community now. And this is, how do you enforce laws abroad? Where are servers located? Where are people speaking to? What if everybody's having an online chat and everybody's in a different jurisdiction?
Yeah.
This all becomes very, very relevant. And while the international community, in some respects, has a lot of commonality, a lot of intellectual property law is pretty much universal because of international trade. But this is something we're noticing now with freedom of speech and freedom of expression. It's all down to sort of where servers are based and where people are technically, broadcasting from, and their local
and who
laws.
it's intended for. And so we had a brief chat before pressing record and said that you send out a tweet, it is worldwide. Your audience is worldwide, and as we will come to, depending on who hears it or reads it, as the case is with Twitter, it can have a bearing in your own jurisdiction, even if the reader is international and somewhere further away. So if we go back to Article 10, this does qualify it. This is the qualification. So it's not an absolute right. The exercise of these freedoms, those freedoms being the freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers, i.e. regardless of where you are. But it's a qualified right in that the exercise of these freedoms, since it carries with it duties and responsibilities. Now, wherever there is some kind of benefit, there is normally a duty and a responsibility that goes hand in hand. So wherever there is a freedom, there is often a duty and responsibility that comes along with it. May be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and necessary in a democratic society. It's a very fancy way of saying you can say anything you like as long as we haven't created some law or restriction that stops you from saying it and will punish you for doing it if we don't like it. Now, a lot of people will disagree with that, but this is what the law is. So it's just a clarification that this is not, at least in England and Wales, is not an absolute right to say anything that you wish. And it's usually in the interest of national security, territorial integrity, or public safety, or, and here's a big key one, the prevention of disorder or crime for the protection of health and morals, and so on and so forth, rights and reputation of others. And this is another one that's come up recently, hasn't it, Al? Because reputational rights of others. So you might have the right to do or to say something, but that doesn't mean you can interfere with the rights of others and curtail their rights or freedoms.
That's why countries are allowed to have defamation laws. That's the provision that allows them to have it.
Indeed.
Because, reputation of others. One thing to remember about sort of rights in general, whether it's human rights, generally speaking, they only restrict state bodies and state organisations. It's what we call vertical effect. It's basically, it's an up and down relationship. One thing to remember about whether it's the Human Rights Act or the US Constitution, these initially only have an effect. They only restrict state bodies from passing laws and things. They're not necessarily having an effect on private organisations or private companies. It's what we call vertical effect. In other words, it's the powers that be that are restricted. It doesn't necessarily stop equals doing things. However, there's also what we call horizontal effect. And there are sometimes you can say, well, I have a right and it's being abused by actually a non-state body. However, the state is allowing that to happen. The right to life is a classic one. If you are being persecuted by a particular group, for instance, that's not a state actor, but the state doesn't prosecute them or doesn't protect you, then you can say, well, that's breaching my Article 2 right to life right, so you must pass a law. But this is very interesting, you see, because when we come on to the Fifth Circuit thing, that is something that imposes basically a duty on private companies, particularly social media companies. I mean, at the risk of spoilers, effectively the US Fifth Circuit have upheld a Texas law saying that social media companies can't prohibit anybody saying anything. And we'll come on to that later on. Yeah. But that's something to bear in mind, that generally speaking, and you get people online say, what about my First Amendment rights? Or what about my right to free speech? If you're on somebody's website or platform or private group, they can just say, our terms and conditions say we can do what we want. You can't start quoting Article 10 at somebody just because they block you from their website or their radio show.
Yeah, indeed. And coming back to the sort of broad subject of offences, so you can exercise your right to say what you wish, but provided that it doesn't overlap with any other kind of offence. And a very good way of giving an overview for this is looking at the communications offences, and in particular the mental element, i.e. the mens rea. So for those that like the Latin, you've got actus reus, the act of doing something, in the mens rea, the mental state. What was the intention? And looking at that mental element of this, where these offences are generally considered, the mental element here, which I've obviously highlighted, that the suspect's purpose, or one such purpose, is that the message should cause distress or anxiety to the recipient. And here's an important bit, or to any other person to whom it's intended that the message or its contents or nature should be communicated. Now, that is very, very broad, because if we take Twitter as the example, anything that you write on Twitter, to think about it, to whom is that intended to be communicated? Well, everybody. It's a worldwide platform. It is public domain. It is intended to be communicated to everybody. So as many particularly as many comedians have said, there's no right not to be offended. Well, actually, it might not be a right, but it could be an offence. So there's not necessarily a right not to be offended by something, but what anybody says on a public platform such as Twitter is intended to be communicated to everybody, the world, everybody, everywhere that has access to Twitter. Now, that could constitute an offence if the mental element is that it's to be communicated to everybody and that one purpose or such purpose is to cause distress or anxiety to anybody. So the short version of that is if you tweet something that's designed to cause anxiety to somebody, you're committing an offence. Yeah. That sounds fairly restrictive to me.
Well, it is. And also, you see, we to get to general legal principles, if you tweet something, you do intend it to be read by everybody. You might not want it to be, but the law doesn't use intention and want synonymously. You can intend something if it's the last thing you actually wanted. And also note that it's the intention to publish, not the intention to cause alarm, harassment, or distress. You can say, well, I never intended to upset anybody. If, however, objectively you do upset somebody, and objectively, you know, the average person would say, well, I can see why that would upset them. You intended to do that. You might go, well, it's the last thing. I wasn't aiming at anybody else. I was just having a one-on-one conversation with somebody else, and I didn't mean to offend them. That's not necessarily defence. It doesn't matter what you wanted. It doesn't matter that you weren't aiming this at anybody else. You intended to publish it to everybody else, and if those words turn out to be objectively offending, then you intended to publish them. And that's what catches a lot of people out. You know, that's the whole thing about mens rea. We say it's what's your state of mind, but it's not necessarily what you're seeking to achieve. It's what actually happens. If something is a virtual and logical certainty based on what your voluntary actions, then you intended to do it, whether you even thought about whether you were going to do it.
Yeah. And looking at another section here is equally interesting. If I bring this back on screen here, we've got very often the CPS, by the way, produce a lot of guidance on their website. It's designed not just for prosecutors, but really for anybody generally that is interested in looking at how prosecutors will look at this. And again, for international viewers, I think this is a very good resource because it doesn't just really pertain to England and Wales. Of course, the law does, but it is a very good way of looking, and international prosecutors will look at how other jurisdictions look at prosecuting certain offences. So therefore, this is quite interesting. So under this whole section, prosecutors should only proceed if they're satisfied there's sufficient evidence that the communication in question is more than, i.e. crosses a threshold, to protect the freedom of expression, even unwelcome freedom of expression. If it's crosses a threshold for being offensive, shocking, or disturbing, or a whole list of other things. And so there's a lot of guidance in here as to what will or will not cross that threshold and should or should not be prosecuted. And this is a very long page, and it discusses lots of different things, including issues in social media offending. This part addresses the various issues commonly arise in social media cases, provides guidance on the approach to be taken relevant to each issue. And again, there's lots of different sections in here to do with social media, and it goes on to hate crime and then social media hate crime and so on and so forth. All of which, on 2 or more occasions, amounts to a course of conduct, as we call it, which is the basis for harassment. And so harassment is pretty much that which is designed to cause an alarm and a distress on at least 2 occasions. And so that amounts to a course of conduct that becomes harassment. And then that is under the Protection of from Harassment Act of 1997, which has inserted into it several different fairly new offences. Those who have been following the Alex Belfield case will know that stalking is one of those such new offences. Now, of course, we can't talk specifically about that case, but we can talk about the offence itself. And again, as I said here, it's a course of conduct which is in breach of this sort of general protection from harassment. And this is the interesting bit that, again, I think we'll talk about in general terms, because a lot of people are sort of confused about it, worried about it, upset about it, and perhaps quite rightly so. The course of conduct amounts to stalking. Stalking, when anyone talks about it, I've done one video on this. If I find it, I'll link it in the description below. If I forget, please remind me, because I always forget. But stalking, everyone would normally think about as turning up to someone's property, looking through the window, shouting things and threatening people and that sort of thing. But that's not necessarily the case, and that's what the big upheaval was with this case with Alex Belfield. Again, not speaking specifically about his case, but the offence itself. It says the listed behaviours are, whilst there's no legally defined or definition of stalking, but it includes listed behaviours: following a person, contacting or attempting to contact a person by any means, publishing any statement or material or purporting to relate to a person or purporting to originate from a person, monitoring, and this potentially an interesting point with this bot Sentinel discussion that I saw on Twitter yesterday, the monitoring the use by a person of the internet, email or other form of electronic communication. This could potentially be caught by this legislation.
I mean, this is, we've moved on, like I say, originally you would have, a lot of offences that you'd have assumed like a physical thing, like stalking, it's following somebody around, turning up on their doorstep. A lot of these offences can be committed electronically. And one of the things with the common law is trying to fit new situations into existing law. And sometimes you can do that. I mean, when they introduce the idea of psychiatric harm, in other words, non-physical ABH and GBH, they said, that just fits within the 1861 Act. It just says serious harm. These days we recognise psychiatric injury can be serious harm, so we don't need a new law for it.
Yeah. As in, it's already covered. And it's an interesting point because as a very brief tangent, I had a discussion with someone by email just the other day about drones and whether council can ban drones. And so, of course, the easiest way for a council to deal with complaints is to say, okay, we'll just raise a bylaw to ban it. Therefore, it shouldn't happen anymore. But a bylaw shouldn't be created where it interferes with existing legislation that already deals with that issue. And in the case of drones, the CAA have already dealt with it quite substantially. So a bylaw could technically be ineffective from the outset because it interferes with existing legislation. But as Al just said, the opposite can be true, where there's legislation already in place that courts can then say, well, this law covers these main elements of it, therefore no need for new law, we'll just shoehorn it into existing legislation. But then of course we have, if I bring back on screen once more, we have other acts with other offences, such as the Crime and Disorder Act of 1988, which sort of overlaps with the Protection from Harassment Act 1997 and stalking offences. And so there's an overlap of offences in here where there is stalking and harassment involved.
Well, yeah, I mean, that's one thing. It's not uncommon to have different laws covering effectively the same offence. I mean, Dan, your speciality is knife law, and there's about 3 different acts that all prohibit the same thing, because you'll have a moral panic about, something must be done, we need to prevent people carrying knives. And it's like, well, we already have laws about that, but we'll do another one that has exactly the same effect.
Yeah.
And again, that's another right. That's another thing that's a lot more complicated than people, it's not a blanket ban. But that's a topic for another day.
Yeah.
But what we try to do is they'll quite often try to squeeze new situations into existing legislation. But if they then find there is a lacuna in the law, as we like to say, they may say, well, we'll create a specific offence to cover this, or we'll do an act that adds a new provision to an existing act. And that's effectively what they'll do here and say, well, we've always covered following people and tracking their movements. We'll just expand that to include doing it electronically.
Yeah. And there was an interesting, again, on the same tangent with the knife law, I fairly brazenly talk about the knife law because my personal view, not that I often give a personal view, but with the subject of knives, I do give a personal view in that I don't think anyone should need to carry one unless, maybe if you're going hiking, you're going camping, you're going climbing, you're going, whatever it might be that you need some kind of blade with you for whatever purpose, as long as it's a good reason as the law requires. Otherwise, within English law, if it's a folding pocket knife, and I literally bought this one for the sole purpose of saying that this is a legal folding pocket knife, because it's immediately foldable at all times, as the courts have decided that it should be. It's no more than 3 inches, and so on and so forth. Some people then say you shouldn't talk about the law and tell people what they are legally allowed to carry. But my response to that is, well, why not? Because the law is publicly available. Just because I talk about it doesn't make it any more publicly available than it was before. I'm just explaining what it is. And in fact, on the contrary, I see and have done videos on some videos that try to say, I think if I take a GoPro connector here, it was about that big, but it was a knife blade on here, and it was sort of concealed as a bit of jewelry, and they say, ha, here's a knife, and this is legal because it's under 3 inches. Like, well, no, it's not. It's not legal because it doesn't fold. Now, a knife that big, if that was a knife that big is illegal to carry around, but this is legal because it's a folding pocket knife, because it folds. That's what the law says. And so this, you can see the reasoning behind it, because it can be concealed. It can be much more dangerous in that sense. This is a tool, as they said in Parliament, and there's a record of it. There's a record of everything said in Parliament, which is called Hansard. You can Google it. You can find it. They said the law wasn't intended to restrict you from carrying tools around. But anyway, the point of that little ramble was that this law is all here. It's all here to see, which is why the CPS produced this legal guidance. Yeah, you can see in the breadcrumb trail here, even there it says legal guidance. Not advice, you understand. None of this is legal advice. Legal guidance. So everything we tell you is legal guidance. So yeah, the law does often cover those things. Now, there was an interesting case that you sent to me, Al. So fill the void while I find the specific quote that you wanted from it.
Well, the classic case on freedom of speech is one called Redmond Bate and DPP. And just by way of background, a lady was preaching on some steps. She was doing like Christian ministry. And she was pushing some views that some people found offensive, and it was all about to kick off. And the police said, "Can you stop talking, because you're provoking everybody, and we're going to have a breach of the peace. I'm nicking you for breach of the peace." But ultimately, this case went to appeal, and there were some quite good quotes. It's a judge called Sedley, Judge Sedley, who's famous among lawyers for something called Sedley's Rules of Documents, which I'll have to dig out at some stage. But the issue there was, well, look, if people are going to say things and it's going to cause public disorder, they shouldn't be allowed to say it. However, Sedley said, free speech includes not only the inoffensive, but the irritating, the contentious, the eccentric, the heretical, the unwelcome, and the provocative, provided it does not tend to provoke violence. Freedom only to speak inoffensively is not worth having. So that was a very, very key case. And the confusion still arose over the tendency to provoke violence. And what some authorities, and this is something that we've seen with very recent events, with people holding up bits of paper and other people taking offence to that, and there's a risk that it's all going to kick off. Is that provoking violence? Well, later cases have established that the onus is on the people who are offended to restrain from violence. It's not for you to keep your mouth shut just because somebody might deck you, effectively, to over-summarise the law. I mean, you can still provoke violence, because you could be saying, obviously an obvious one is go assault somebody or go take out that person or that group of people. Then obviously that is provoking violence. And when you get into the borderline stuff, like if you walk into, a Rangers pub and start sort of going on about how brilliant Celtic are, are you asking for it? And generally speaking, the idea with the law is that you should be allowed to say what you want, and it should be other people to accommodate that. However, it does recognise that sometimes it's not a defence in law to say he was asking for it, but effectively there is sometimes saying, well, what you were saying there, the Americans call it fighting words, which I think is a beautiful phrase that the Supreme Court use. And it's the fighting words doctrine. Are you effectively offering somebody out or trying to provoke a fight? But this is the boundary, and these laws come in, and the ones that they use a lot in public, because I do a lot of, public order sort of advice for activists and things like that. And it's the main offences there are Section 4 and Section 5, which are putting people in apprehension of causing alarm, harassment, or distress. And it used to say that included insulting people. That has been specifically removed from the legislation now. And what's interesting is some people are saying, well, that means that freedom of speech has been expanded. Other people have said, well, no, insulting was superfluous because it was already bound up in the causing alarm, harassment, and distress aspect. So, it was a redundancy. And again, this is one of these things. And generally speaking, lawyers tend to sort of say words are only in an act if they meant to mean something. We always assume that parliamentary draftspeople are super efficient and will not put something in unless it actually makes a difference. So the stronger argument is by removing the insulting component, that did change the law. It wasn't just a bit of editing. But there's a new act now. There's a new offence of effectively causing public nuisance, which overlaps because there's other offences of causing public nuisance to do with environment and things. But it's all very, we need new words. But that includes, and this was specifically targeted at people like Extinction Rebellion, and it's an offence to cause serious or real annoyance. And that's a very nebulous concept. I mean, people say, well, that was for if people were blocking a road, that's obviously very annoying and we needed a rule against that. Well, it's an offence to obstruct the highway. It's an offence to do most things that interfere with other people's freedoms and rights, whether it's blocking roads, blocking entrances to things, picketing, having demonstrations. These can all be restricted. So it's not really been tested yet. But what do we mean by real annoyance? Is it so? If, for instance, somebody holds a sign up and everybody says, "Well, I don't find it offensive or insulting, but you're just annoying." Say I'm doing my sort of hippie vegan thing. I mean, one group of people find annoying vegans. Is it now an offence to sort of like start banging on about animal rights or veganism? Because lots of people find that annoying. So will that sort of tick the boxes? Because the argument is most of the conduct that is used to justify that law is already unlawful. So what does it bring to the party? And the general one consensus point of view is it's just to expand sort of restrictions on free speech, and it's a way of clamping down on people we find annoying. Not that they're causing any harm or disruption. It's just that they are advocating a cause that most people don't agree with, or a significant number of people don't agree with. And so the idea of being criminalised for being annoying, is slightly concerning. But we'll have to see how that develops.
Yeah, it's in itself, ironically, seems somewhat offensive, doesn't it? So, and yeah, I think the way this is worded here. A person commits an offence if the person does an act that obstructs the public or a section of the public to exercise the enjoyment of a right might be exercised by or enjoyed by the public at large, and often referred to as quiet enjoyment. And so, yeah, if you interfering with someone else's quiet enjoyment of their walk about the park or whatever, again, coming back to, I think the comedians often sum this up very nicely. There's no right not to be offended by anything, and whereas the law does provide that if you say something that can cause alarm, distress, or now annoyance, that might be an offence. Well, isn't that the same thing? And are we treading on lines here? And so I think we're coming close to the edges here, aren't we? Really, but that just coming back to your point about this case, Al. And again, this was a case which was heard, obviously, right at the top. And the wording, free speech includes not only the inoffensive, but the irritating, contentious, eccentric. Yeah, so it sums it up nicely. But this seems to go against what some of the drafted legislation actually says. So it's no wonder that some people are often confused, because this takes a lot of interpretation. I had a comment which I think was it started out as a bit of an insulting comment, but then turned into a conversation about the law just being information and that we shouldn't be paid just to provide this information. I said, well, it's very much more than just information. It takes a lot of analysis, interpretation, and as you often say, Al, knowing the judge, and more generally, knowing what a judge will rule, what a judge is likely to rule. We're instructed sometimes to provide not just advice, but opinion. Now, many lawyers will say that's the same thing. I take the view that it's not quite the same thing, because an advice is, this is what the law is, this is what your situation is, this is what the law says about your situation, that's it, that's the advice. You know, strategically and pragmatically, you might do X, Y, or Z. An opinion, I think, is very nuanced and different to that, because an opinion is, well, what do I think the outcome is going to be in court? Well, that takes some real analysis and judgment, or prejudgment if you like, as to what might happen in court. Now, of course, we can't be right all the time, and unless we're downright negligent, which I think most of us are not ever going to be, but unless we're downright negligent, you can't just come back and sue us because we're wrong. It was an opinion. It was our opinion, but the judge can always overrule it and say this is going to happen. We're not often wrong. It depends on how you phrase it, I suppose, doesn't it?
Well, usually you cover every conceivable contingency. I mean, again, people like the behind-the-scenes stuff and, you know, the terminology. Barristers, one thing barristers are asked to do a lot is to provide advices or opinions. And like Dan's saying, they are documents that someone will say, right, I have a legal issue here, but I don't know what to do about it. I'll instruct counsel. And it's quite funny because the terms advice and opinion do get used interchangeably a lot. And what you tend to find is they use this thing that anything about criminal matters, they'd call it an advice. Anything about civil, they'd call it an opinion. But yeah, there are this idea that they're actually really separate things. They're distinct creatures, because the advice is, please write me advice, and it will be something like, you should sue, or you should not sue, or you should defend in this way. An opinion is a bit more general. Well, here's some potential causes of action. Here's what your options are. So there probably is this distinction. But one thing, like Dan said, first of all, barristers, we tend never to commit too hard. We'll only speak in terms of probabilities. It's like quantum physics. We never give a definitive thing. It's actually a professional negligence issue to give definitive advice. So even if you go, this is a complete slam dunk, or this case will be struck out, you've still got to qualify it. Well, it should be. There's no reason for this case not to be struck out. But saying something will definitely happen can get you into trouble. I used to write advices for insurance companies for whether they should fund litigation, and I was asked to advise on quantum once to see if it was worth doing. And I without really thinking, I sort of wrote, I said, and in conclusion, this claim could be worth up to X, like pounds, or possibly even more. And they came back and said, so what you're saying is somewhere between 0 and infinity. That's really helpful. Thank you. Cover the option. I bet you're right. I bet it's somewhere.
Interestingly enough, I've had to advise on GDPR and breach of GDPR, and again, that's come up in Twitter in the last day or two. And this was a case, without obviously giving any details really, where the bank had sent documents to the wrong party, having separated, disclosing to the other party the new address when they shouldn't have done. And that's a fairly serious breach. So again, I was asked for an advice as to what it might be worth. It was in the many thousands, and I believe the bank settled it in the end, because that's one such area. Well, is it an advice or is it an opinion? Well, it is sort of both. It's an advice in the sense that, well, these are all the other cases that are very, very, very similar. So the advice would be that it's somewhere between this and this, being these two cases that are, one is a little bit more serious than this and one is similar but not so serious, so it falls between the two, is where we often go. As to merits and the opinion, well, the opinion would have been, well, this is a fairly strong case because it's a matter of fact that this has been disclosed to the wrong party. And then speaking of, I'm just looking on screen, actually, I'll bring on screen the US case that you were talking about, because this then we come into this public versus private body and how the law applies to them. So this is very interesting for our international viewers. So bringing back on screen, let you talk about it, Al, because you found it.
Yeah, well, it's pointed out by our lovely US colleagues. So we said, generally speaking, the idea is that it's only all the restrictions, all the rights. It only applies against the government bodies, and private companies can do what they want. And that's something we'll come on to about your employer, can they regulate what you do, what you say out of work and things. But this is a case, and as it says at the top, a social media platform may not block, ban, remove, deplatform, demonetize, deboost, restrict, deny equal access or visibility, or otherwise discriminate against a user for the user's expression or the user's ability to receive the expression of another person based on the user's viewpoint. The user viewpoint represented, or the geographic location. I mean, the location one perhaps isn't as important, but what this effectively means is, if you have a platform where you allow people to speak, you cannot pick and choose who you allow to speak. So does this mean Twitter can have terms and conditions anymore about what can be said? The argument is no, they can't. I mean, there was a previous ruling in another state, because this is a case from Texas. But just to explain, again, all American viewers will know this. In the US, there's actually 54 separate jurisdictions. Okay, some states, some commonwealths. But they also have circuits. So each of those states will be like maybe 4 to 6 states will all be part of one circuit, and that circuit will have its own Supreme Court before it goes off to the Supreme Court. So this is a decision of the Fifth Circuit, and Texas is in the Fifth Circuit. So Texas says, we've got this law saying social media companies can't pick and choose who they have on, and they can't restrict what they say, and they can't penalise anybody in any way for what they say. And the social media companies obviously appeal this and say, well, no, because otherwise, we should be like control hate speech, and there's other competing interests we have there. So this went off to the Fifth Circuit Supreme Court, who said, no, the companies are not allowed to restrict. So this will undoubtedly go to the Supreme Court, because there's a conflicting case, I think it's Florida case, that says, of course, private companies can impose what terms and conditions they want, and they don't have to give explanations. They're not a government body. They can do what they want. So this is the conflict. But yeah, this was a very surprising decision, and people have commented about the politics of everything. But yeah, at the moment, if you live in Texas and you're sort of going on Twitter, and Twitter, blocks you or removes your tweet, you can sue them. You can sue them. That's what this is.
It's typically the reverse is true, isn't it? You got a private body. They can have their own private terms and conditions, and they can choose what they do and how they do it, so long as, again, this overlap with the law, so long as they're not discriminating unlawfully. So again, fairly universal. You have what we call them protected characteristics, and they're referred to differently elsewhere, but characteristics nonetheless, and anything from gender, race, religion, sexual orientation, and so on and so forth. If you unlawfully discriminate against somebody, or i.e. you treat them less favorably because of one of those characteristics, then that would be unlawful. But that's not to say you can't set up, let's say you wanted to set up a women-only gym or something like that, then that's what you are. It's not, it was set up in a positive way rather than a restrictive way. If you were to say, no one who is in any way disabled is allowed to come here, then that would obviously be discriminatory, and you can't do that. But otherwise, companies are allowed to make up their own terms and conditions. But now this is flying in the face of that. But again, there'll be an overlap with other law, so it's interesting to see. I mean, this is fairly clear cut. Bring it back on screen. It's fairly clear cut. May not block, ban, remove, deplatform, demonetize, deboost, restrict, deny equal access or visibility to, etc. But what if is the next question. What if it's someone that is, let's say, making serious threats of harm against another? Surely they should be allowed to block and restrict that. I mean, there's an overlap. There has to be an overlap here. which is why I agree with Al. It's going to go off, and it's going to be. I expect it probably come back in some halfway house.
But you lead us into a very nice thing there, because we can talk now about sort of your restrictions by other people, like your employers. And the thing is that the law can recognise that you can hold an opinion and you can express an opinion, but how you express that opinion and whether there are any restrictions on it, that's not as clear cut. Because one other thing we get is what we call protected beliefs, which is you cannot be penalised or treated more poorly as a result of either having a protected belief or, interestingly, not having one, although that gets complicated. So, say for an obvious example, religion. Religion's protected belief. So you can't sort of do a blanket ban. You can't say, no Muslims, no Hindus, no Christians, no Zoroastrians. And the reverse is true there. You can't discriminate for somebody for not having a protected belief. So you can't say you must be a Zoroastrian to work here, unless, of course, Zoroastrian temple, because then it's arguably a sort of, a genuine occupational requirement. But it's any philosophical belief. Now, this is what's very interesting. It's got to be an irrational belief. If you just if it's a political belief or it's a belief you've arrived at through reasoning, then it might not be protected. But veganism is actually a protected belief because of our good friend Geordie, who took this case all the way to court, and it all went through all the appeals. And so veganism is a protected belief, okay? And you can't be penalised expressing those beliefs or holding those beliefs. But it's all free for all. We're not allowed to sort of go in and prod people and say, "Oh, you stop eating that ham sandwich in front of us." We're allowed to hold the belief. We can express the belief, but again, we live in a society where there's competing interests and other people have different viewpoints. So, our belief and our freedoms stop where they start interfering with other people's. But what about talking about things? And this is something that crops up. Again, another restriction is your employer. Employers are allowed to take into account reputation management. So can they restrict what you say out of work? What if you're tweeting away and you're going with a political opinion that's very unpopular? Well, political thought isn't as protected as, like, say, philosophical beliefs, because that's something you arrive at rationally. Although, generally speaking, people are allowed free and private lives, and they can sort of say, "I support this party," or "I support that party." There may be a situation where you run a drop-in centre for sort of like vulnerable minorities, and somebody is a member of a far-right organisation that's tweeting, send them back or whatever. That might be something to say, well, we can interfere with that because that's work-related. Okay? But this has cropped up with sort of like, gender-critical beliefs. The case I cite a lot is there's somebody, he was a hunt sab, and he worked for a particular company in a rural area, and all the local farmers and horse riders said, "Oi, he's all right paying him, why?" So they sacked him. They said, "Look, people are boycotting us because of your beliefs." But he went to tribunal, and they said, "Well, actually, my belief is in the sanctity of animal life. It's not a rational belief." Loads of people could say, "Well, no, animals don't have rights, don't have feelings." So I'm not arguing it on a political point of view or a scientific or a rational basis. I'm just saying that's what I believe. And they said, "Okay, it's a protected belief then," and they had to carry on employing it. So, but again, it's how you manifest those beliefs and opinions. So you are allowed to say, "I believe, I believe this, and these are my views." But if you start harassing anybody who doesn't agree with those views, or calling them names, or using a term that they don't want, so the pronouns thing is a big thing. If you say, "Well, I don't accept this. I think sex is immutable." I'm not going to get into the fundamentals of that, but say somebody is saying that. But then online they're dealing with an individual, and they're sort of misgendering them. That can cross the line into harassment. So your workplace can say, "Well, actually, that is reflecting badly on our reputation, and we can do something out." They say, "Well, no, but that's a protected belief." They say, "Yes, protected belief, but the manifestation of that belief might not be protected." So it all gets very, very complicated. But like I say, this is something that your employee can do. And one that's cropped up recently for us, I've had a really nice Twitter chat with a couple of people the other day, and they were saying about, barristers on social media, because of course we have our own regulator, we have the Bar Standards Board, and how far can we go in what we say. And it's probably fair to say there are more restrictions on us because we have this thing where we can't do anything to bring the bar into disrepute. Also, we can't do anything that looks like it might be compromising our independence. Now, barristers can have views, but this is why I'm always very clear that, you know, my animal rights views are pretty much on my sleeve. But another interest is the fact that I'm a strict adherent and huge fan of the cab rank rule and the independence of the bar. And I make that very clear. What are various views on animal agriculture? But if, you know, and I do work for farmers and the fishing fleet, and I have to do the best job I can for them. You know, we'll sit in the pub afterwards and I'll give them a hard time about, you know, murdering cows and things. And then they know that because they instruct me because they know I will fight their corner for them.
And that's the key. It's the key to knowing that your barrister is going to fight for you. And it's like a phrase I used the other day is, you know, I will fight for your right to disagree with me. And, you know, it's choosing someone at the bar is effectively that. Is you're taking an advocate who will vehemently, fearlessly promote your case within the rules, whether they agree with it or not. And absolutely, you make some really good points, Al, because actually there are lots of different viewpoints expressed by individuals, and some people will criticize the individual for expressing those points. Now, I would say that just think for a moment, regardless of whether that person is making those comments, think just imagine for the moment. I mean, it may be true that they actually hold those views, but just think for a moment that the person making those comments may not necessarily wholeheartedly push and support those views themselves, but they're pushing a cause. Now, obviously, many of them that do make comments like that obviously do hold those views, but just take for the moment that maybe they don't. Maybe that they've chosen, let's say, Al, and your veganism. Let's say, I'm sure you do care, but let's say just for a moment that actually you don't care. Let's say that just for a moment that you don't care, but you've chosen that you are going to push and promote this cause because, you know, whatever the reason is, you've just, or you've been instructed to, and this is where we come on to instructions at the bar. Take it as though you were instructed to do that. It matters not whether you actually hold those views or otherwise. You're pushing and promoting that cause. And I think as soon as you can do that and you detach the individual from the views, then suddenly there's no need to hate and you know, ostracize the individual for making those comments, because they're very, very often compartmentalized, aren't they, Al?
Well, yeah, I'm a big, you know, you play the ball, not the man. Obviously, metaphorically speaking, anybody who's ever seen me play five-a-side, not that they do now because I'm banned, will know that is a phrase I use metaphorically rather than literally.
Yeah.
But yeah, this is the whole point. You know, if somebody is saying something you disagree with, attack the argument, but don't attack the person. I mean, I'm not going to name any names here. There are other barristers out there of proper opinions, and sometimes we might disagree with their opinion, might agree with it. But the fact is that person gets a lot of stick that is completely irrelevant to the comments and to the argument. They're horrible, nasty personal attacks. And it's like, no, that person is allowed to say what they want in the same way that you can. You can say what you want about the argument, but you don't go after the person. You know, you know, the old ad hominem attacks. And to be perfectly frank, it's like with advocacy in general. If you're at the end of the day reduced to just abusing the witness, that means you don't have a case. If you can't attack the evidence, or you can't attack their argument, or you can't undermine the factual basis of what they're saying, then maybe have a think about should you even be having a go at them at all. You know, this is something, and you know, we're back to freedom of speech. It is very important, you know, the marketplace of ideas, and there are restrictions. I mean, I am not a free speech absolutist. I don't have any problem with restrictions on hate speech. And, you know, one person's hate speech is another person's, they would say, legitimate comment. Actually, I think you can spot the difference.
Yeah,
but this is something that's cropped up in international law. You know, the Rwanda War Crimes Tribunal did a lot of radio hosts because they were effectively it was what called stochastic terrorism. They weren't actually saying go out and kill these people, but they were doing these people are scum and these people and they do this and they do that. And they said, well, that is, especially in a civil war, that is effectively inciting the civil war. But also it was the justification we used for bombing Radio Yugoslavia back in the day. I'm showing my age there, where NATO took out a radio station. And there was a big argument about that, going, that was just a civilian infrastructure, just broadcasting news. And they said it wasn't broadcasting news, and it wasn't even just broadcasting propaganda. It was effectively broadcasting incitement to genocide. And that was the justification. So, I'm not a free speech absolutist, but I do think people, the mere fact that you disagree with somebody or you find what they're saying is offensive or even incomprehensible or stupid, attack the argument, point out and say, bring the receipts. This is why I disagree with you. This is why my conclusion is different. But don't just start abusing people and basically proving their point a lot of the time. About what
exactly. It's like with all my arguments on the Depp Heard trial and the analysis of the UK judgment. Look, it's one perspective, it's one analysis, it's one viewpoint, it's one set of arguments. I will stand by the arguments that I've made and said, well, this is inconsistent with this, and this should have been applied. You've got hearsay disapplied or discounted in one sense, where it's been applied in another. Well, as the phrase seems to crop up these days, you can't have it both ways, or you shouldn't have it both ways. But I'm perfectly happy for someone to come up with their own arguments and disagree with me. I'm not going to ridicule someone else for coming up with other arguments that disagree with mine. But in return, I would also expect that someone doesn't discredit me for making those arguments, because, again, as I think I've said before, it matters not whether I am or am not a Johnny Depp fan. I mean, I'm not a fan as such. Yes, I've watched the films. That's about it. But this is entirely beside the point. And I think one of the points we creep onto talking about that trial again. But one of the points is that I read actually, I think it was yesterday or the day before, this was very, very much more than this trial and this pair, if you like. And I've said that in previous videos as well. I did a whole video out on Black Belt Secrets about it. Why I'm talking about this? Well, the simple reason I've been talking about this trial is because I've had clients that have been through horrendous situations and vile and, just frankly immoral accusations, been through a 3 or 4 year process to get a not proven by the family court judge at the end of it. And that's it. I just expected to go on as though nothing happened. Only it did. It turned upside down 3 years of their life. And, some of them are denied access. To put this into context, before we come back to the subject, but to put this into context, some of these people are denied access to their children. They can't even live at home. They might be on bail conditions for related offences because it gets reported to the police, and so they can't even live at home, and they can't see their children for months and months on end, if not years on end. Someone's life's been turned upside down for at least 4 or 5 years, only at the end of it not guilty, and sorry about that. Actually, there isn't really a sorry about that. It's just a not guilty. But anyway, so there's always a broader context to all this. And that's why we make the arguments. It's for the discussion. And that's where we come full circle. It's the freedom of expression, freedom of speech. It's all about proper discussion. I think that sums it up nicely, doesn't it, Al? It's proper discussion.
I think so. It's proper, yeah, because it's about, the sort of public debate. Now, interesting, a QC friend, KC friend now, the wonderful Bernard Richmond, Fat Silk on Twitter, PHAT, he made a really good point, because he's not interested in all this social media type stuff, but he was saying about, he does a lot of the advocacy training. He's the guy who sort of mentored me. And he's saying, when you're reading about all these cases that we all study, remember, behind those cases are real people. This was something, we all sort of like, what happened, Tharbo Malley, the poor chap that you learn about, your first time you learn about murder, the guy who was thrown off the cliff. It's like, actually, that was we're looking at this, this is interesting. And I'm very fascinated by, the Dudley and Stevens case, the cannibal case. But that was a pretty horrendous case. And it's the same thing, I think. I'm a big fan now. I've moved my position. I'm a big fan of televised trials, because I think they really help illustrate the process. And it gives us an opportunity to try and demystify the law by pointing to examples. But as I've said before numerous times, at the heart of that case and other cases, there are real humans effectively having their intimate, most vulnerable secrets and disgraceful behaviour forensically dissected in front of a public audience. That's a horrible experience for everybody, and I'm always and it's not just that trial. There are other trials, because that's the thing with in the law. Barristers, we meet people at very horrible times in their lives, because nobody wants to litigate.
Yeah.
Well, apart from vexation.
Well, even if they think they do, people often think they want to take this to court, but when they're halfway through it, they wish they never started.
Yeah.
And so our almost, unless you're a huge, almost faceless corporation protecting its IP that, well, litigation is every day of the week. Unless you're that, which most people aren't, our blanket advice is don't litigate if you can help it, because you won't enjoy it. Even if you win, you'd often wish you hadn't bothered.
Yep. So I keep coming back to my, I've been ruined but twice. Once when I lost a lawsuit, once when I won one. And that's not just financial ruin. That litigation is horrible. So we are very, and some people raise some very legitimate points about, well, the vulnerable people here, and is this adding to their sort of trauma? Yeah. But the fact is, people need to know about commentary, and it's this idea, are we expected to be neutral? I've said before, I see as like, as sports commentators, we can comment on a match, and we can say if the match is going well or badly for one side or the other. We can comment on, that was a bit of a dirty tactic, or that was a good, and we can suggest tactics. He should bring on a midfielder now, or what he could do is this. So, and that's effectively what we're doing. Sometimes, though, when you comment on a case, you come to a particular conclusion and say, well, actually, that case, that was a rubbish argument, that was a terrible argument, that witness didn't come across well. And the point is to explain to people, this is why they didn't come across well, because it's all information we want you to know. It's not just about the general, yes, it's quite interesting. It's some practical benefit for you. If you're ever in a situation where, you're forced to be a witness, here's how to deal with being a witness. Here's how to be a good witness. Yeah. And you can use, you are using real people. And I think, with trials, and there's lots of trials where you can sort of, sometimes there's a range of opinions. You can sort of say, well, I can, that trial could have gone either way. I can see the judge made that decision. It was a good decision. There is an argument as to why there's an alternative decision that judge could have made, especially in appeal court stuff. I mean, that Fifth Circuit case, the judges that was actually a 3-2 decision. But when you hear the two sides of the argument, three of the judges are going, it's really obvious that the law is this. And it's ludicrous that anybody argued otherwise. And their judicial colleagues are going, no, it's not. It's ludicrous that you're arguing that. Yeah. So, there's always room for opinion. And one thing that I think lawyers cope a lot with is this idea of Wednesbury unreasonableness. Now that somebody's taught me how to pronounce that properly, because the last time I kept saying Wednesbury, and they're going, no, I live there, it's Wednesbury. That's a case we took. It's a case where one of the parties was Wednesbury Picture House. And that introduced or highlighted the concept that there are no definitive wrong or right answers a lot of the time in law. It's not like, here's an objectively correct decision you made, Judge. It's, did your decision fall within a range of reasonable responses? And so long as it's like not completely an outlier that nobody, and that's the test. Yeah. It's only a reasonable decision. Nobody would have thought that. But the mere fact that most people would have thought this, but somebody else, another judge, thought something different, as long as he can point and say, well, no, a couple of judges might have said that, or a couple of people. And it's not just judges. This crops up in like medical negligence cases, a thing called the Bowman test, which is, well, just because 95% of heart surgeons think this is the best way to do that operation, and this guy did it a different way. There are a handful of surgeons who think that's an equally valid operation. So it's not negligent, merely that... And
here's an interesting point then, because my analysis on the UK judgment in that trial, I would wager, I mean, what's happened and everything's moved on. But my analysis being what it is, I would suspect that although judge will obviously stick to his judgment, but would probably still say, yeah, I can see some force in the argument. Don't agree with you, but I can see force in your arguments. He it would not, I dare say, would not say that's so unreasonable, no one would ever possibly think that, because of course a lot of people agree with me. And so that sort of brings it into context, doesn't it? It's entirely possible that judge would say, yeah, I can see your analysis on my judgment. That's entirely possible. So I think people should bear that in mind as well.
No, don't forget, I mean, we've said before that when you're appealing, the first person you ask for permission to appeal is the judge who just made the decision. Now, generally speaking, judges sort of will say, well, I think I got it right, so no, try your luck with the appeal court.
Yeah.
But some judges will say, actually, you've got a point now, see what you say. I don't agree with you.
Don't agree with you, but I see your argument.
I'm going to certify this that you can trot off to the appeal court because they might come back and say a different decision. There's one judge who's lovely because he would always, you'd go, any other matters? And you go, well, there's one matter. And he goes, is this permission to appeal? Yes. And presumably your grounds are that I should have retired years ago. I haven't got a clue what I'm doing. I said, I'm not going to frame it like that, obviously. I'm going to frame it slightly differently. But he was quite open about the fact that, people would appeal his decisions. And sometimes would give permission to appeal on the grounds that, well, I don't agree with this, but, see what somebody else may well say. Because this is the other thing. People say, oh, judges don't like being appealed, and it's really insulting to appeal a judge, and you're implying some misconduct or something. No, judges appealed all the time, and they don't care.
It's not exactly... it's not what it's chalked up to be. It's not like a judge is going to be insulted because their judgment's being analysed and taken apart piece by piece. It's just, I wouldn't go as far as saying I don't care, but it's just.
In the US, they sometimes, because they have elected judges there, and they have appointed judges, often appointed by various Congress and state bodies. And one question that quite often they'll set a thing that must not have been appealed successfully appealed more than X time. But it's like, well, hang on a minute. People doing cutting edge areas of the law quite often.
It'll be appealed all the time. Yeah.
There's a lot of cases actually in this country that are now considered to be settled law, but because they've gone through every appeal court, it can be said where most judges who looked at that case came to one conclusion, and it was only the fact that ultimately it got in front of 5 people in the House of Lords and they went to a different conclusion. So it's not uncommon for cases to actually more judges thought one way than the other way, but it just happened that the judges outranked them
collectively. Yeah, absolutely. And I suspect this area of freedom of speech and expression is going to be one of those, because it's going to come down. I think some cases are going to come down to one word. Is this one word or phrase crossing the line? And I think we will get cases like that go to high courts and decide whether someone should be allowed to say that or not. I mean, with some of the I'm not going to particularize them, but some of the complaints about what people have said in various institutions that have been reported in the media, I've thought, really, you're being punished for saying that? And I think some of them are outrageous, but they'll be for the courts to decide ultimately, won't they? So absolutely, there it is.
Yeah. Well, it'd be interesting to read people's comments about that, because try just because. Remember, we're not in Texas.
No, exactly. So if you are still here and you're still watching, well done, first of all, but also for sticking with us, but also in the comments below. Not that they'll be directed at anyone in particular, obviously, but a comment that you would find offensive that you think the law should restrict, and perhaps something that you think shouldn't be restricted. And without directing them at anyone in particular. And with that, I think I've said all I have to say, unless you have any closing comments, Al.
No, I think we covered everything. I mean, as always, we will no doubt expand on this, because there's all sorts of things about what's the limits of what you can tweet, and we'll chat about the Robin Hood case at some stage. I just like to give little teasers so people go, oh, what's the Robin Hood case?
Yeah, well,
and then I'll say it's about an airport, and then people go, oh, it's that case. I thought you were on about the real Robin Hood.
Indeed. Well, very interesting discussion. I hope you all enjoyed it. Please do like the video and subscribe in case you haven't already. And as we keep promising, we will be coming back on our art and media law channel. So that's linked in the description as well. Make sure you're subscribed there. And as always, thank you very much for watching.